On July 1, 2026, the new Florida House Bill 999 officially takes effect. The legislation recognizes qualifying gold and silver coins as legal tender and removes state sales tax on approved precious metals. This has created a professional misconception that multi-million-dollar real estate can be purchased by simply handing physical gold to a seller. Legal tender status at the state level does not override federal law or commercial necessity. Hand-to-hand metal transfers are incompatible with institutional finance. Institutional settlement requires a structured architecture involving professional custody, attorney escrow, and verified digital workflows. Consider a $2.8 million commercial acquisition funded through a sound money collateral pool. The challenge is practical. You must execute this settlement, satisfying a seller who demands US dollars and an IRS that mandates capital gains reporting. Navigating this requires 4 specific guardrails. First, optional acceptance, secure electronic custody, the LBO collateral workaround, and federal tax compliance. HB 999 provides the legal foundation for structured sound money finance, but only for those who maintain strict commercial discipline. The first guardrail is optionality. Under HB 999, the acceptance of gold or silver is voluntary. Commercial sellers, title companies, and escrow agents retain the right to refuse precious metals and demand fiat currency. Because acceptance is voluntary, these settlements are governed entirely by private contract law. If a seller consents to accept metal, the specific parameters of that exchange must be detailed in the escrow instructions. These instructions define the conversion methods, the designated spot rate sources, and the vaulting delivery requirements. Without this explicit contractual consent, the physical metal remains commercially inert. A sound money settlement is a private agreement that requires mutual consent on the exact mechanisms of value transfer before the closing can proceed. The second guardrail is the requirement for an unbroken institutional chain of custody. Physical gold must be deposited into a qualified public depository or vaulting network. To interface with modern closing attorneys, the physical metal must be translated into encrypted electronic ledger data. This ledger provides documented proof of the owner's identity, the asset's physical location, its market value, and the absence of competing liens. This authenticated data is the only evidence that satisfies a commercial proof of funds requirement. The bullion provides the underlying weight and purity, but the actual transaction relies entirely on the velocity and trust of verified electronic records. In our $2.8 million case study, the seller refuses gold and demands payment in US dollars. This requires the leveraged buyout, or LBO, workaround. The buyer pledges their verified vault claim as collateral to an institutional lender. The lender advances 60 to 70% of the metal's value in liquid fiat, based on the loan-to-value ratio. This step follows UCC Article 9 discipline for secured transactions. The lender files a UCC-1 financing statement in the public record to perfect their security interest against the vaulted gold. Once the interest is perfected, the lender wires the fiat currency directly into the appro's attorney escrow account. The seller receives the specific US dollars required for the real estate. The buyer acquires the property while retaining title to their underlying sound money reserve, subject to the lender's lien. This LBO structure allows investors to deploy purchasing power without liquidating their foundational hard assets. The final guardrail is that federal tax law takes precedence over state-level exemptions. While HB 999 removes Florida sales tax, it provides no protection against federal IRS liabilities. Spending or directly liquidating appreciated precious metals triggers a taxable capital gains event, often at federal collectibles rates. This reinforces the utility of the LBO workaround. Borrowing against an asset generally does not trigger a taxable sale, which preserves the investor's tax basis. Because tax architecture dictates the settlement structure, professional CPA review is required before moving or pledging any sound money. In this $2.8 million closing, the full architecture ensures all conditions precedent are satisfied. When every layer is aligned, the closing attorney establishes the final disbursement authority. The Florida statute creates a pathway for gold settlement, but it does not remove the need for standard commercial rigor. Physical gold and silver do not become institutional capital simply by existing in a vault. These assets become bankable capital only through custody, electronic verification, UCC discipline, and escrow controls. In modern capital markets, sound money is defined as verified value under lawful control. When properly structured, sound money transforms from a philosophical ideal into a functional, auditable asset class ready for capital deployment.